Moving on to issue number 8, dealing with the death penalty. Again, I would like to thank for the detailed information in the report, the answers provided to our list of issues. We welcome the fact that more and more states abolish the death penalty. We welcome the fact that the number of executions is declining in most states that retain it. The study authorized by Attorney General Eric Holder addressing the overrepresentation of African Americans in the death row population, this study is most welcome. It highlights concerns shared by this committee too. Discrimination is bad, but it's utterly unacceptable when it leads to death. Just some days ago, Glenn Ford, an Afro-American wrongly convicted by an all-white jury more than a quarter of a century ago, was exonerated on the basis of newly discovered evidence. He's already the 144th case of exoneration of a person wrongly sentenced to death since 1973, I'm informed. 144 cases of wrongfully convicted persons convicted to death is a staggering number. It points, at least to me, to fundamental flaws in the judicial system administering the death penalty. As does the report I just mentioned, I'm also concerned about the administration of untested legal drugs. I understand that in January of this year it took Dennis McGuire 15 to 20 minutes to die, an execution that may have amounted to cruel and inhuman treatment. I also understand that the state of Mississippi plans to execute 2 individuals later this month as we meet here, despite the fact that up to now it has not shown that the pentobarbital that will be used has been acquired from legal sources, has not yet expired, has still the full effect on the person to which it will be administered. Mr. Chair, please allow me to ask in this context the following questions. First, what is the federal government planning to do to effectively ensure that the death penalty is not imposed as a result of racial bias? The Access to Justice initiative is certainly an important step, but does the distinguished delegation think it's sufficient to address the identified far-reaching problems? To what extent does this initiative solve also the problem of legal representation for litigants in death penalty-related civil cases?
I'm addressing the death penalty issues you raised in particular, and those questions are ones that we especially appreciate because they mirror in many ways the debate within the United States. As noted at the outset, the number of states imposing the death penalty, the number of individuals on death row, the number of executions have all declined over the last decade. Nonetheless, the death penalty does remain both a federal possible sanction as well as a sanction in a number of states, consistent with Article 6 of the ICCPR in the sense that it is only for the most serious crimes. But the issues, Mr. Kalin, that you've raised are ones that we have examined ourselves as well. There's a concern, of course, to ensure that the death penalty is imposed only on those that are actually guilty of the serious crime, and that it's not done in a way that expresses racial disparity. And let me address some of the ways in which we're doing this. It takes place really at all levels of the process. In the first place, before the death penalty can be sought, as you noted, Mr. Kalin, Attorney General Holder has put in place a new capital case review protocol. This was suggested by consultation with federal judges, with prosecutors, with defense counsel. It's to ensure that the Department of Justice's decision-making process is fair and that it's imposing the death penalty only in appropriate cases, and to make sure that it's done in a non-discriminatory manner. In addition, the Attorney General has announced a racial disparity working group made up of the U.S. attorneys designed to study these issues as well. And I should say that goes across the board with regard to criminal justice issues. So the first point is that the death penalty can only be sought with these kind of protections in place. The second is that both at the federal and state level, there are heightened procedural safeguards to ensure that the death penalty is appropriately imposed in a particular case. All death penalty statutes must guide the discretion of the fact finder and must narrow the class of offenders that are possibly subject to the death penalty. Additionally, the capital defendant must be given the right to an individualized determination that the death penalty is appropriate in his or her case. And the jury must give effect to any mitigating evidence. As I think has been previously noted, but would like to emphasize here, the Department of Justice has also committed resources to ensuring that there are capital case litigation, defense counsel, and others, and have worked with states to increase the ability of those representing those that might be charged with the death penalty. And then at the time of sentencing itself, United States law expressly prohibits the imposition of the death penalty on the basis of race and requires that each capital case be considered on an individual basis. Still, as you suggest, Mr. Kalin, the overrepresentation of minority persons, particularly blacks and African Americans, in the death row population remains a serious concern. And our Department of Justice Bureau of Statistics continues to study this issue, and we continue to put in place the kind of safeguards that I have mentioned previously, both with regard to the decision to seek, the actual prosecution, and the sentencing of those that are convicted of a death-eligible offense. But beyond that, of course, we also have post-conviction review, including habeas corpus review. You've mentioned, Mr. Kalin.
Second, does the distinguished delegation share the opinion that the fact that 16 retentionist states do not provide for compensation for the wrongfully convicted, and that some other states just provide for symbolic compensation, that this fact is incompatible with the right to effective remedies under the Covenant?
You've mentioned, Mr. Kalin, the number of cases that have resulted in exoneration. And of course, any conviction of someone who has been wrongfully convicted is a matter of concern. In many ways, these cases of exoneration can be seen as a vindication of the system working. These are cases in which individuals who were convicted have nonetheless been exonerated. And you've also raised the question of what kind of compensation may be given to those individuals. That, of course, will vary from state to state given our federal system, but at present, 29 of our states, plus the District of Columbia, as well as the federal government, have statutes providing compensation for wrongful conviction. In addition, the Federal Innocence Protection Act provides $100,000 for each year of incarceration for any plaintiff wrongfully sentenced to death. It also expresses the sense of the United States Congress that states should provide reasonable compensation to any person who has been wrongfully convicted.
Under the Covenant.
And finally,
third, what is the federal government planning to stop the use of drugs for executions that are not approved by the U.S. Food and Drug Administration?
And finally, turning to the question of lethal injection, you've raised the issue of the narcotics or the drugs that may be used in this regard. And in this context, I can note that federal courts have recently exercised authority to hear lawsuits challenging state execution protocols and the use of certain drugs on constitutional grounds. And we expect that this practice is likely to continue.
Mr. Kalin also asked a question about how the states deal with wrongful convictions. I myself have signed agreed orders releasing people from prison who were wrongfully convicted. Thanks to DNA and our more common use of DNA testing, we're able to detect those who were wrongfully convicted. And the states do pay and compensate those people who have been wrongfully convicted. In our poor state, for example, we pay $50,000 a year, up to $500,000 to those who have been wrongfully convicted. And we're one of the poor states, so we're sort of probably in the middle as to how states address that issue. You know, some of these common misconceptions about states such as Mississippi, because of our history, we have stereotypes, and you know, international reports some of the time indicate that some legislation passed in our states is off base, and many times some of the acts are. But the great part about our system of government in America is we have a federal safety net, and the federal courts many times ameliorate some of these odd acts that occur in our state legislatures that really get out in the media, yet they don't necessarily ever take effect. I will be the president of the National Association of Attorneys General starting in June. And I assure you that the questions that you have raised, I will raise with my colleagues, so that the states will be aware of many of the questions that we're asked about our compliance with treaties, and hopefully we can make changes in our states so that we can move forward to protect our people and make our country and our world a better place to live. Thank you.
And fourth, why does the state of Mississippi not release information about where they got the drugs envisaged to be used in the 2 planned executions? Does not inform about what kind of drugs they are, when they expire, and how they will be prepared for use in these 2 executions? Why is the state of Mississippi in this way depriving the 2 individuals concerned from using available remedies effectively? In the absence of such information, these 2 persons are obviously unable to substantiate their claim that the drugs envisaged for use would lead to suffering amounting to cruel and inhuman treatment. Is the state of Mississippi confident that, in light of the fact that many capital defendants have received deficient trial, appellate, post-conviction representation, is not going to execute another innocent person? I'm not claiming that they are innocent. I'm just wondering, in light of the large number of exonerations, whether we can be sure that they are.
Our past. Now, specifically to address Mr. Kalin's questions about lethal injection, unfortunately some of the defense attorneys representing clients in death penalty cases have created some misinformation and misconceptions in the media. The medication used in lethal injections in the state of Mississippi was changed about 2 years ago. We changed to a medication called pentobarbital, which is used in surgery commonly. The misconception being that somehow that was done in secret is incorrect. We changed to that drug there again, which is commonly used in surgery. It was addressed by the lower federal district court and on appeal, so we use a drug that's commonly used. And these drugs are not outdated. That's another misconception that we've had to address.
I just wanted to add one question, because I see that time is running away with this. It's a very important concern pertaining to effective compliance by the United States with their obligations in terms of human rights when the right to life is at stake. I'm talking here about the fact that in Texas, Escatamayo Arias was executed. This is a person who had interim measures extended to them under the Inter-American Court, and indeed the Inter-American Court of Human Rights found that the right to due process had been violated because the consular notification under the Vienna Convention on the Law of Treaties was not respected. Some state civil servants have spoken out because in Texas this person was executed. But of course this doesn't go far enough. I'd like to know what measures are being taken by the state, what effective measures are being taken to ensure that within each of the individual states within the United States, when a situation arises that is so serious, such as the right to not be arbitrarily deprived of life, what is happening to ensure that decisions taken by international bodies are complied with. We often work to defend the work of the Inter-American Commission of Human Rights, and a good way of doing this is to pay attention to what the Inter-American Commission of Human Rights says to the state. Thank you very much, sir.
Let me then turn to the third question, and that's the question that's been raised by Mr. Savioli regarding death penalty and AVENA obligations. Here, too, this is an issue that the administration takes very seriously. In fact, both the Obama administration and before that, the Bush administration have taken steps designed to try and come into compliance with our international legal obligations in this context. President Bush sought to take executive action, and when that was not successful under the Supreme Court's ruling in the Medellin case, legislation was introduced. I, in fact, testified in connection with that legislation before the United States Senate, and the administration continues to reintroduce that legislation. But beyond that, we have also taken steps designed to work with the states in which these individuals are imprisoned and on death row. Both the assistant and acting legal advisor, Mary McLeod, and I traveled to Texas earlier this year to meet with the Texas Attorney General's office in particular with regard to these cases. And we are committed, both with regard to legislative action and whatever executive action or whatever work with the states can be achieved, to bring ourselves into compliance with this important obligation. Thank you.
I would like in particular to thank Attorney General Hood for his response, his plan to bring to the attention our discussions, to bring our discussions to the attention to his colleagues is one example of what is needed to follow up at the state and local levels. One question to him. Can Attorney General Hood confirm that the pentobarbital to be used is not a synthetic form of the drug coming from a compounding pharmacy that is unregulated by the U.S. Food and Drug Association?
Mr. Kalin, you ask about pentobarbital. It is a drug that is approved by the Food and Drug Administration for purposes of surgery, anesthesia. And it is compounded by a licensed pharmacist in the United States.